Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. I will dictate a full passage without any stop. The facts relevant for the purpose culled out from the record are that the respondent employee joined service as a clerk cum typist in the year 1973 and while in service committed serious irregularities in discharge of his duties was placed under suspension by an order dated 7th August 1995. He was later served with the charge sheet along with the statement of allegation on 2nd March 1996. After the disciplinary inquiry was conducted in accordance with the disciplinary rules of the bank, the inquiry officer found the charges proved. In consequence thereof, the respondent was dismissed from service by an order dated 6th December 2000, and the appellate authority also rejected the appeal preferred by the respondent employee by an order dated 24th April 2004. The learned tribunal, after taking into consideration the record of the domestic inquiry, finally arrived to the conclusion that inquiry was fair and proper and the charges stood proved, but while exercising power under Section 11A of the Act 1947, the tribunal, under its award dated 30th December 2005, observed that the punishment awarded to the respondent employee of dismissal is not commensurate with the charge levelled against him, and accordingly, while upholding the allegations levelled against the respondent in reference to which the inquiry was conducted, substituted the punishment of dismissal with an order of reinstatement after lowering down of two stages in his basic salary that he was getting at the time of his dismissal. It was also held that there will be no payment of salary and allowances for the period of his suspension save and except payment of subsistence allowance on a writ petition being preferred by the appellant in assailing the interference made by the tribunal in exercise of its power under Section 11A of the Act 1947, the learned single judge, by an order dated 25th July 2006, dismissed the petition, holding that the tribunal has a discretion under Section 11A of the Act 1947 and held that it has rightly been exercised, which further came to be challenged at the instance of the appellant in letters patent appeal before the division bench of the High Court. The division bench has upheld the finding returned by the tribunal and confirmed by the learned single judge under the order impugned, which has been categorically referred to in para 3 of the order. However, the division bench was not inclined to interfere despite the fact that the respondent was found guilty after regular inquiry had been held for misappropriation of funds, and further observed that there should not be any compassion in the judicial proceedings which should be shown to the delinquent who commits such nature of fraud in discharge of his duties, but still refused to interfere with the order of the tribunal for the reason that the respondent employee by that time had retired on attaining the age of superannuation in 2007. The nature of allegation against the respondent employee was of fraudulently preparing 9 credit transfer vouchers on various dates on the pretext of payment of interest towards fixed deposits and crediting the whole amount to one saving account opened in the name of one Srimati Asha Devi, admittedly the fake account prepared by respondent employee. In order to adjust the said amount, he manipulated the other book records of the bank using forged signatures. After such nature of allegations stood proved, the disciplinary authority, after taking into consideration the record of inquiry and the post held by the respondent employee, punished him with the penalty of dismissal from service. The finding of guilt recorded by the inquiry officer in his report was confirmed at all later stages by the disciplinary appellate authority, and even after judicial scrutiny by the division bench in the impugned judgment, but still refrained from interference on the premise that the employee had superannuated in the year 2007. In our considered view, looking into seriousness of the nature of allegations leveled against the respondent employee, the punishment of dismissal inflicted upon him in no manner could be said to be shockingly disproportionate, which would have required to be interfered with by the tribunal in exercise of its power under Section 11A of the Act 1947. At the same time, merely because the employee stood superannuated in the meanwhile will not absolve him from the misconduct which he had committed in discharge of his duties, and looking into the nature of misconduct which he had committed, he was not entitled for any indulgence. The bank employee always holds the position of trust where honesty and integrity are the sine qua non, but it would never be advisable to deal with such matters leniently. Consequently, the appeal succeeds and is allowed. The interference made by the tribunal and the High Court in the impugned judgment is hereby set aside. There will be no order as to cause.